Good afternoon. Welcome to a webinar on the visa process to bring foreign artists to your stages. I'm Pennie Ojeda, Director of International Activities at the National Endowment for the Arts, and I'm delighted to welcome you to our second webinar on O&P temporary employment visas. I'm here with Mary Herman, who is with the Department of Homeland Security's Office of Citizenship and Immigration Services. So here's what we'll cover over the next hour. Here's what we'll cover over the next hour. I'll offer some background and then turn it over to Mary for about a 30-minute presentation, followed by time for questions. And by the way, you are all muted and will only be able to hear us. You can submit questions at any time using the Q&A box below the PowerPoint. Please do not use the raise hand button for questions. Mary will do her best to address as many questions as possible during the time we have. This webinar will be posted in podcasts, webcasts, and webinars section of the NEA website in a few days, so you can refer to it in the future. And we'll hold a Twitter chat with Mary and several of her colleagues on July 15th. Over the last decade, the National Arts Service organizations, such as the League of American Symphonies, Dance USA, Theater Communications Group, Opera America, and a few others, have helped their fields navigate the process for temporary employment visas for foreign artists. They've formed a visa working group to educate and assist arts organizations to comply with all aspects of the visa process. The working group developed a useful resource to assist the field, the website artistsfromabroad.org. The site was updated late in 2012 to improve its navigation. Arrows on the screen point to a few of the improvements. Topic bars on the left, a search feature, and there is the ability to print it as a PDF. The website is currently being revised with new links to relevant sections of the Department of State and Department of Homeland Security websites. You might want to bookmark artistsfromabroad.org along with the archive of this webinar and the previous one you'll find on our website as resources for when you undertake the visa process in the future. Today, our guest, Mary Herman, Acting Chief of the Public Engagement Division of the U.S. Citizenship and Immigration Services, will give you an overview of USCIS and its role in the visa process. She'll discuss the O&P classification categories and eligibility, the petition review, and will give you some tips for filing the petition. Welcome, Mary.
Thank you so much, Pennie, and good afternoon, everyone who's joining on the phone and via the webinar. I appreciate the opportunity to join all of you today. I'm also joined by colleagues who are dialing in remotely from our offices of Policy and Strategy, our Office of Chief Counsel, as well as our Service Center Operations Directorate, and they'll be able to assist with some of the questions later in today's webinar. I do have quite a lot of information to get through today, so hopefully we'll still have a good amount of time for questions, but just putting it out there that this is a pretty dense presentation, so I will do my best to get through it quickly, and hopefully the presentation itself will actually address a lot of the questions that you may have. So again, just getting started, we are U.S. Citizenship and Immigration Services, and today we're going to be talking about the O&P category. So just as an overview, who are we at USCIS and what is our role in the process? So USCIS is a component of DHS, or the Department of Homeland Security, and we are the government agency that oversees lawful immigration to the U.S. Our officers adjudicate applications and petitions for a wide variety of immigration benefits, as we call them, and that includes those that are for non-immigrant visa petitions, which the O&P, of course, fall within. USCIS must approve the petition before an individual can then apply in his or her country at their embassy or consulate. So who are the other pieces of the puzzle and what is their role? I know that you recently had an engagement with the Department of State, who I know spoke to a lot of the participants about their role, which is that they're responsible for processing overseas immigrant and non-immigrant visa applications for individuals who are seeking legal entry into the U.S. They establish the visa application processing and issuance fees, and of course, by going to their website, you can find out more information about their process. And then the entire process also would involve U.S. Customs and Border Protection, or CBP, who then physically admit immigrants and non-immigrants into the U.S. and have the final authority for granting admission into the United States. What is a non-immigrant? An individual can seek to enter the U.S. as an immigrant or non-immigrant, and a non-immigrant worker is an individual who is seeking to work temporarily in the U.S. And of course, the O&P visa categories are just two of the classification types for non-immigrant workers. This is what we'll discuss today. We'll talk about what is required for both the O&P categories, how to apply under each of these categories, and then at the end we'll talk about some filing tips as well too, to avoid some common errors. So what are the O&P categories? They're divided into a number of subcategories. Generally speaking, O visas are granted to individuals who are considered to have extraordinary ability or achievement, and P visas are granted to athletes, performers, and or entertainers. Within the O category, you have, I think, probably of most interest to the folks who are joining today, there's the O1B category that's about arts or motion pictures and TV. There's the O2 category, which is for individuals who would be assisting those in the O1 category. And then, of course, there's O3, which is for the family members. And we'll talk about each of these in more detail a little bit later. Within the P category, there's P1B, which is entertainment group members, P2, which is for reciprocal exchange program performers, P3, which is culturally unique program performers, and finally PS, which are the essential support personnel. So in terms of filing a petition, what is required? The petitioner needs to file the Form I-129, which is a petition for a non-immigrant worker. And I should note that all of the forms, instructions, and everything that you would need is available on our website, which is uscis.gov. The form should be filed with the USCIS office that's listed in the form instructions, along with all the required evidence and all applicable fees. And we'll talk a little bit about the evidence as well. In addition to the I-129, the evidence that must be included is a copy of the contract between the petitioner and the beneficiary, or a summary of the terms if there's an oral agreement under which the beneficiary will be employed. You must also provide an explanation of the nature of the events, the beginning and ending dates for the activities, and an itinerary with the dates and locations of the performances. Also, you would need to provide a written consultation from an appropriate labor organization regarding the nature of the work to be done, and specific requirements, of course, for each classification would apply also. In terms of the consultation, a consultation is a written advisory opinion that would come from a peer group, including labor organizations, or a person who's been designated by the group with expertise in the beneficiary's area of ability. Are there exceptions to the consultation requirement? Yes. If the petitioner can demonstrate that an appropriate peer group does not exist, the decision is then based on the evidence of record. The consultation can be waived for an alien with extraordinary ability in the field of arts if the individual seeks readmission to perform similar services within 2 years of the date of a previous consultation. In that case, the petitioner should submit a waiver request and a copy of the previous consultation with the petition. So who can file O and P petitions? It should be a U.S. employer. It's important to note for O beneficiaries that they cannot self-petition, a U.S. agent, a sponsoring organization, which would be for those applying under the P category, or a foreign employer through a U.S. agent. And I would direct anybody who is interested in more information on that to the 8 CFR. I won't read out the citation, but it's there on the screen for those of you who may want to follow it. In terms of filing the petition may not be filed more than 1 year before the actual need for the alien services. In terms of the different categories, under the O category, there's O1A, which are individuals with extraordinary ability in the sciences, education, business, or athletics. This does not include arts, motion pictures, or the television industry, which is O1B, which is for those individuals with extraordinary ability in arts or extraordinary achievement in motion picture or television. O2, which are individuals who accompany an O1 artist or athlete, and they assist in a specific event or performance. And then finally, there are the O3, which are the spouse or children of O1s and 2s. In terms of O1B eligibility and the terminology extraordinary ability, with context of the arts, this means distinction. Distinction is a high level of achievement in the arts. This can be shown by a degree of skill and recognition substantially above that ordinarily encountered. And normally the person is described as prominent or is renowned, leading, or well-known in that field of art. With respect to extraordinary achievement in motion pictures and TV, this means somebody with a very high level of accomplishment. This can be shown by a degree of skill and recognition that's significantly above what is ordinarily encountered, or the person is recognized as outstanding, notable, or leading in the motion picture or television field. So just to show a little bit of the difference between the arts ability and that for movie and TV, motion pictures and television achievement. On the art side, it's a high level of achievement. Movie and TV, we're looking at a very high level of accomplishment. Again, on the art side, the skill and recognition must be above the ordinary. For motion picture and television, the skill and recognition must be significantly above the ordinary. On the art side, the person is renowned, leading, or well-known in the arts. For movies and TV, the person is outstanding, notable, or leading in their particular field. With respect to O2 eligibility, individuals who come temporarily to the U.S. solely to assist in the artistic or athletic performance by an O1, if somebody is coming as an O2 for an artist, they would assist in the performance of an O1. They must be integral to the part of the actual performance and have critical skills and experience with the O1, which are not of a general nature and are not possessed by a U.S. worker. Also, just to touch on the O3 a little bit, these generally, it's a spouse or child under the age of 21. They would be accompanying the individual or would follow to join. They may not work in the U.S., but may study full or part-time, and in order to apply for an extension, can file an I-539 to stay on. And that actually leads us to the period of stay or extension of stay for the O category. The period of time permitted would be the time required to complete the event or activity. It cannot exceed 3 years. If somebody is traveling in the O2 category, their period of stay would be the same as an O1. And the O1 can be admitted to the U.S. up to 10 days before and remain in the U.S. up to 10 days after that individual's authorized period of stay. However, the beneficiary may only engage in employment during the validity date of the petition. We can now move on and talk a bit about the P category. Again, there are a number of subcategories, and I won't go through these again, but we'll touch on these a little bit more going forward. In terms of eligibility for the P1B, you need to be able to show evidence that the group has been established and performing regularly for at least a year. There should be a statement from the petitioner listing each member of the group and the exact dates for which each member has been employed on a regular basis by the group, and also provide evidence that the group is internationally recognized as outstanding in their discipline for a sustained and substantial period of time. Within the P2 subcategory, the individual, performer, or group under a reciprocal exchange program, they must be coming to the U.S. temporarily to perform as an artist or entertainer, either individually or as part of a group that is performing under a reciprocal exchange program between an organization in the U.S. and another country. And they must also possess skills that are comparable to those of the U.S. artists and entertainers taking part in the program and the reciprocal program outside the U.S. In terms of required evidence, the sponsoring labor organization in the U.S. or the U.S. employer must file evidence that all the exchange artists subject to the reciprocal agreement are artists who have comparable skills and that the terms and conditions of employment are, of course, similar. They must also provide evidence that an appropriate labor organization in the U.S. was involved in negotiating or has at least concurred with the reciprocal exchange between the U.S. and the foreign artists or entertainers. Moving on to the P3 category, this is for an artist or entertainer who is part of a culturally unique program. The P3 is for those coming to the U.S. either, again, individually or as part of a group for the purpose of developing, interpreting, representing, coaching, or teaching a unique or traditional ethnic, folk, cultural, musical, theatrical, or artistic performance or presentation. I know that's quite the laundry list. And they will then participate in a cultural event which will further the understanding or development of their art form. And the program can be both of a commercial or a non-commercial nature. In terms of required evidence, documentation from recognized experts that attest to the authenticity of the skills of the aliens is required, and that could include credentials of the expert, including the basis of his or her knowledge of the group skills, or documentation that the alien or group's performance is culturally unique. In terms of the period of stay for under the P categories, the initial period of stay is up to 3 years. USCIS will determine the time necessary for the individual group to accomplish the initial event or activity in increments of 1 year, although it may be extended. And the individual may be admitted to the U.S. for the validity period of the petition, plus a period of up to 10 days before the validity period begins, and again 10 days after the validity period ends. Of course, during that time, the individual can only engage in authorized employment during the actual validity period of the petition. In terms of the decision process, the petitioner and or their authorized representative, if there is one on the petition, would be notified of the decision. If a petition is denied, the petitioner will be notified of the reasons for the denial and the right to appeal the denial. An appeal, if filed, should be filed within 30 days from the date of the decision. And that's from the date of the decision, so whatever date is on the notification and not the date that the actual decision was received. The beneficiary of the visa petition is not permitted to file the appeal or motion. Only the petitioner can file an appeal or motion in this instance. So now I wanted to go through a couple of, or quite a few actually, filing tips that hopefully will assist those of you who are putting together these petitions. Some of them are pretty straightforward, but I'll go through them anyways. One thing is to make sure that you include all applicable fees. Make sure the forms are signed and dates are included where they're needed. I know this probably sounds fairly obvious, but you would be surprised by the number of times that we receive petitions that don't have all this required information. For those agents who are filing on behalf of multiple employers, the petitioner should include the contracts that have been executed with the actual employers. And what's very helpful is to submit a table of contents for the list of evidence and present the achievement or ability evidence in order that it's actually described within the regulations. I'll move on to the next slide. If awards or honors are submitted other than, say, a Nobel Prize or an Academy Award, which are obviously very, very well known, you should provide documentation that establishes the significance of the award. For instance, is it a national or international award that as required for that specific classification? If documentation is provided, for instance, that the beneficiary has performed in a lead or starring role, you should also provide documentation to support the second part of the criterion, that is that the production or the event at which the beneficiary performed the lead role has a distinguished reputation. Also, if providing evidence through publications, it's helpful to highlight the beneficiary's name if mentioned in those publications. And the newspaper, trade journal, magazine, etc., that are submitted must be a copy of the article in the specific publication with the author and the date shown on the article submitted, and the documentation establishing the size or area of the publication, so we have context for the actual publication. If somebody provides web documents, they must be a print of the actual document found on the web with the website, date of printing, and evidence documenting the size or reach of the online publication, again, so we have context for that evidence. It's also helpful to note that independent letters of support carry more weight than letters from people the beneficiary has worked with in the past. And then finally, I wanted to just point to some resources that are available on our website. I know Pennie had mentioned earlier the Artists from Abroad website, but I would also direct all of you to visit our website, which is www.uscis.gov. And while I know a lot of work has gone into putting together the Artists from Abroad website, uscis.gov is the official source of information, and what we've gone through today is primarily found on the website. I think we just were able to put it together in a little bit more of a concise fashion, so hopefully this has been helpful to you. But if any of the questions that you may have, or later if you're interested in more information, you can go to uscis.gov. Along the left-hand navigation, or actually it's in the center of the website, you'll find a section on working in the U.S. And if you click on temporary workers, and then on the left-hand navigation is all the drop downs for the various types of of temporary workers, including the O and P, and you can click there for more information. If anybody wants to follow up on their case, you can always contact our National Customer Service line, which is 1-800-375-5283, although you can actually follow up on an application or petition online as well, too. And I will mention that individuals can do a couple of things electronically these days with USCIS. One, you can follow up on the status of your case online using the Case Status Online function. And also, you can actually submit an inquiry on your case. We have an e-request function, which can be found from the USCIS homepage as well. It's on the left-hand side of the navigation. And you can click on that and actually similar to calling the call center, but not having to wait for a customer service representative to assist you, you can submit your request that way. You would actually get an email back giving you a sort of confirmation number that we received your inquiry, and then the inquiry is actually followed up in the same fashion as if you had gone through the 1-800 number. And then finally, in terms of our public engagement division, you are always welcome to contact us. If it's a non-case specific question, we'd certainly be happy to provide you with resources and other points of contact. And our email address is public.engagement@uscis.dhs.gov. Thank you so much, Penny. I guess we're ready for questions now.
Thank you, Mary, for that comprehensive presentation. We'll open it up for questions. And I see we have a few up here. Allison asks if 2 of 5 members of a group already have valid visas, is it okay to submit an application for the 3 who do not need a visa, or do we need to submit listing all members? And I know Mary has some colleagues available off-site, so she will either take the question or field it to one of them.
Okay. I'm just going to double check to see that my colleagues are on the line from USCIS.
Hi, Mary and Penny. Yes, we're here. We'll get back to you in just
great.
1 second on your question.
In the meantime, there's a question from Karen that's saying that most of this is great. This is great info. Are there key parts that have changed recently?
No, I would say not. And then, and I know that I had mentioned going to the website, and we are actually very diligent about making sure that the information that's provided through uscis.gov is always the most current and up-to-date information. So if individuals are using that as their source of information, then they will always have what is the most pertinent information for them.
Do we have a response for Allison's question about the if 2 of 5 members of a group already have valid visas, or should we move on in the meantime? Off-site folks.
No, this is Julia, and I'm the SME for O's and P's at Service Center Operations. And as far as, I mean, if you have a group and 2 of them already have their visas, and so you're really only petitioning for the 3, those would be the 3 individuals that would be on the petition, but you would want to include all 5 as far as establishing the group, establishing that 75% of them have been performing together for 1 year, you know, and all of the other eligibility requirements. So you're not petitioning for all 5, you're petitioning for 3, but you would want to include all members in terms of describing your group. If that
Great. And
question.
I should add, this is Penny, that SMEs are subject matter experts. So Mary will be fielding the questions off to the subject matter experts. Bill asks if there is a maximum period of no performances that could be approved for a single work permit. If an artist has a tour in November of 2013, and then again in February of 14, could that be covered in what petition? So in other words, what's the longest gap in order to have one petition cover it.
Well, I will throw this over to my my colleagues at USCIS headquarters, but if I do recall, Julia or Paolo, you can perhaps help as well. We did publish the OGAP memo, which I think provides guidance on this, does it not?
Yes, the OGAP memo does talk about this, and really with any type of itinerary that we receive, it's going to really be on a case-by-case basis. So what is important, I mean, if you have a large gap, we can't say like, oh, 1 month is okay, 6 weeks is not. Basically, what we look at is if you can establish that they're coming in to complete an event. And so if the two performances are connected, that you can establish that it is in fact a tour, we could look at that as one event, and that would be fine. I think it's very helpful if there is a large gap that you explain to us in the petition what the performer will be doing during that break, if they're going to be performing overseas, if they're going to be, traveling other places, just so that we have a good idea of just what's going on.
Great, thank you.
And sorry, Julia, I see that we have a couple questions about whether or not this also applies, the guidance on the gap also applies to the P classification as well.
I believe but both the O's and P's, when we're looking at performances that require an itinerary, we do, use the OGAP memo, for both O's and P's.
And for your reference, that was published on July 20th, 2010, and it is available on the website under, I believe it's on the temporary worker page, the O's on the right-hand side.
Yep. Thanks, Paula. And I believe that the memo can also be reached by going through the laws section, and then all of the policy memos are housed under there as well, too.
We have a question from Emily that it relates to the consultation letter and the a specific request for a letter from a union. Can someone give us some guidance on the best approach for consultations? Is there a difference in the requirement between O's and P's and the kind of consultation documentation required?
Well, there are differences for the O's and P's. Essentially, if you are filing for the O1As, which if we're talking performances, probably doesn't fall under that, you can contact a labor organization or management organization or a peer or peer group. When you get into like O2s, they must be with a labor organization is the only acceptable place to get a consultation or advisory opinion. The O1B for motion picture and TV actually requires 2 consultations. You need to have a consultation from a labor organization and also one for a management organization. O1B for the arts only requires, it could be a labor organization, management organization, or a peer group. So there really is differences. I think the best bet is to go to our website, and there is a section that describes who can give these advisory opinions. For the P classifications, I believe all 3 require labor organizations, not peer groups. If you have a particular occupation that does not have a labor organization, then you need to articulate that and let us know that there is not one available when you submit your petition.
There's a related question concerning letters of support from Abby. I think this references, Mary, when you were giving the filing tips.
Yes.
Could you elucidate on that a little?
I think what Abby is referring to is we noted that with the letters of support, if they are independent, they carry more weight than if they came from somebody whom you have been associated with. And I'm not sure in terms of additional clarification what she might be looking for, but if Abby, you want to add to that question through the webinar, that would be helpful.
We have a quick clarification or just a reiteration of information. Again, could someone give the location of the OGAP memo? That seems to be of interest.
So all of our policy memos are found on uscis.gov. Along the very top navigation of uscis.gov, there is a section called Laws, which I know seems interesting that policy would be under laws, but that's where they're all located. So if you go under that tab and then along the left-hand navigation, all of our policy memos are listed there. They're both listed chronologically and then by topic area. And then I think, Paula, you also mentioned that there's a link to it from the O page.
Yeah, that's correct. If you go to our homepage and you click on temporary workers, you'll get basically a list of subjects on the left-hand side, and you can select the O, and you go into the O temporary worker page, and on the right-hand side, you'll find the GAP memo. It'll come up, and that's probably an easier way to get to it.
Probably.
There are a couple of questions that deal with time. So maybe just get a general response on the average time for petition approval from a nonprofit arts organization. We know that there has been great improvement recently, and wonder if you can give us an update on what the turnaround time is like nowadays.
Julia, would you be able to give us an update on that?
Well, I believe this has been for about 2 years. USCIS has made it a real goal to try to adjudicate all O&P petitions in 14 days. That is our goal, what we strive to do. There are certain things that come up, though, which are really out of our hands, which, do delay the processing times a little bit. So, or like if you need to have an RFE, if we have unexpected caseload, petitions coming in that weren't anticipated, things outside our control. But we do keep it as a goal, 14 days. I'll add, too, that both the O and P classifications do allow premium processing. And with that service, we do, guarantee 15-day processing with added benefits, of receiving emails, as soon as it's been receipted in, having RFEs faxed to you, which does, sort of expedite the service. So that is available for all O&P petitions.
I'm going to mention that I see there are a few case-specific questions here, and we're really not going to be able to take those in this webinar, but I think the contact information that Mary gave you previously is a way that you might be able to follow up on specific cases. There's a very specific question here that from Tamara that states that she's been advised to use special 2-hole fasteners for the copies of the petition to be submitted. How important is this?
I have to say that I'm not familiar with that, and I'm not sure if that's something that is being required through the service centers. Julia, are you aware of that?
No, I'm not aware of that at all.
Okay. Tamara, we can look into that, and we'll see if we can figure out if that's actually something that has been required, but not to our knowledge.
And there is a question from Allison related to contracts for O1Bs for dates that are 12 to 18 months out and the final dates and venues aren't confirmed. What kind of documentation would be most helpful in that kind of case when the performances are pretty far out from the time of the petition?
Okay, would you mind asking that question again, please, repeating the question?
I just lost the question on the screen, but it was a situation in which a petition for an O1B, I believe, had performances 12 or 18 months out from the petition date, and the exact dates were not confirmed. How necessary is it to have actual contracts with specific dates?
When performances, like if there's like say a tour, for example, and you have tentative dates going out 12 to 18 months, we will look at that. I mean, because we do understand that industries, they don't always lock in those exact dates that far in advance. But if you can give as much information as possible, contracts with the venues or whatever you have, for as far out as you can go, and then explain that you have these tentative performances planned, to give us an idea as best you can what you have lined up for that 12 to 18 months. And then, it's going to be on a case-by-case basis, but we do try to recognize that, these industries, that it's not all set in stone when you filed the petition.
There is a follow-up question on the goal regarding the goal of the 14-day adjudication, that Kristen appreciates it very much and asks if a decision, even a request for evidence, is not made in 14 days, is there any recourse? What should the petitioner do?
Yeah, I can actually take this one, Penny. An individual can follow up on their case through our National Customer Service Center, and again, that number is 1-800-375-5283.
Another of these technical questions, when you file a petition, do you need to submit a copy, and does CIS return the approved copy of the petition?
Okay. Thanks, that's a good question, Penny. Yeah, you do need to submit a copy of the Form I-129 and the supporting documentation so that we can forward the duplicate copy to the Department of the State. So then USCIS does not return the approved copy to the petitioner.
Nicholas asks, if someone would fall under two categories, how do you decide which takes more precedence, P versus O?
I defer to my colleagues if they have anything to add here, but I don't know that we would be able to necessarily advise someone one way or the other. We don't want to drift into providing any type of legal advice. Obviously, they would need to take a look at both of the categories and see which one that they deem to be the most appropriate, or where they're able to supply the evidence to support either of their claims, and then file accordingly. And my colleagues at headquarters, is there anything else you would want to add there?
No, I think that's good advice.
There's a question from Karen that I'm not sure we can answer here, but maybe you can refer her to a website, because I'm sure you've got this question about artists from Cuba, the status of handling artists from Cuba coming into the United States.
I myself am not familiar with anything specific there. I don't know if the folks at headquarters have anything else to add. I don't know that we have anything specific we can provide there, Penny.
Okay. I think the Department of Treasury might be the place to look under the licensing for Cuban artists coming here, but that's really outside of what we're talking about today. We haven't talked about service centers. If the artist is coming to the United States, traveling to several states, how do you determine which is the correct service center to file a petition?
Thanks, Penny. If the artist's employment involves working at different locations, the address, meaning the state where the petitioning company or organization, which would be listed in Part 1 of the Form I-129, that's what we use to determine the jurisdiction.
And is there any place on the website that has the sort of checklists for information the petitioner would need from the artist in order to complete the I-129? Many of the embassy websites have checklists of what the artist would need when they come in to do the application at the consulate. Is there anything similar on CIS?
Yeah, so actually on the USCIS website, we do have all the information that is needed for filing the Form I-129 for both the O and P petitions, as well as their dependents who would file an I-539. And then within the actual form itself, the I-129, we list all of the required information there. So there's actually a checklist within the Form I-129.
And there's also been no discussion about fees. Could you talk about the fee to file a petition? Is it the same for every country, and how it works in relation to individuals or groups?
Yeah. So the fee to file the petition is $325, and then the fee is the same regardless of what country you're filing from. And I know that Julia had mentioned previously the ability also to use the premium processing, and the fee for that is $1,225 as well.
Carissa's asking about artists coming from Mexico and how many visas is there a maximum? I'm not sure the point of the question. In terms of a time period, I guess she's looking at an optimum time period of applying for P1 and P3 visas in relation to Mexico. Is that something that you can check? Or
Yeah, I guess the question is, maybe I guess I'm just trying to figure out if they're asking whether or not there's a certain time frame that's a better time to apply. I'm thinking maybe she means whether or not there's a slower period to file. I would say, the 12 months of the year for USCIS are very busy, so I wouldn't say that there's one period or another that is better in terms of filing.
And Cynthia is asking a question related to the fee at the consulate for the visa. Could you or your colleagues make a point about the difference between the petition process and fee and the next step that comes after that?
Yeah, so we talked about the different players in the process. So there's our role as USCIS in approving the petition, then the individual files at their embassy or consulate, and then they would actually be admitted by CBP. So in terms of the petition, we mentioned that there's a $325 filing fee for the actual petition, and then there's the fee that individuals would then have to pay to Department of State for the visa processing. And I'm sure that they provided all of that information a couple of weeks ago when they were here.
So Cynthia, if you missed the other webinar, there are two fees. There's one when you file the petition to approve the visa, and then there is a second fee that you pay to the embassy, the consulate, where the artist goes for their interview and actually receives approval for the visa. So there are two fees involved there. You talked about documents in newspapers and journals and so on. Do those need to be submitted in translation?
Yeah, where there's an article that would be in another language, the translator would then need to certify that the translations are accurate and complete, and that the individual is competent to translate from the foreign language into English.
So is there a special certification for the translation?
No, just that the individual would need to be able to show that the translation has been done by somebody who is an official translator.
I think Carrie's question may also relate to the different steps of this process that you've talked about between Department of Homeland Security and the petition at CIS and the State Department and the work that happens in the consulate, she asked, does it matter if an artist applies for an O visa from a country other than their country of residence?
I think if I'm understanding that question, they're talking about somebody who's perhaps traveling abroad in a variety of different countries and doesn't necessarily return to their normal country of residence and submits the application there. Again, in terms of the USCIS process, it would be the petitioner who's in the U.S. who's filing anyways. And with Department of State, I'm not sure what their guidelines are from where you would be able to file for the actual visa.
So, Carrie, the information regarding the consular process where the artist actually goes and submits the application for the visa is in the other webinar, and you can access that from the NEA website to get a fuller answer to your question. Other questions? Someone asks if a foreign artist can file the petition with CIS directly, or is the artist always the beneficiary and it must be filed by someone in the U.S.?
So the Form I-129 may be filed by either a U.S. employer, a U.S. agent, or a foreign employer through a U.S. agent. Petitions may also be filed by a sponsoring organization. I think we mentioned before that beneficiaries can't self-petition either.
Gladys asks, if a beneficiary receives an O-1B visa within 1 year, is it necessary to file for another consultation letter, an I-29, with USCIS to participate in other events?
And I believe we actually had covered this earlier, and I'm just leafing through as well, where we talk about the consultation. I think that's what she's referencing. In terms of the consultation, it can be waived, but for an alien with extraordinary ability in the field of the arts. And I think that she's actually talking about somebody who's filing, to file another consultation letter to participate in other events. If they seek readmission to perform similar services within 2 years of the date of a previous consultation, it might be waived, and they would need to submit a waiver request and a copy of the previous consultation with the petition. And again, my subject matter experts, please correct me if I'm wrong.
No, Mary, you have that right. And I just wanted to say, and that is only for the O-1B arts. The O-1As and the O-1B motion picture TV, they must submit a new consultation for each new event that they are coming in for.
And Kristen asks if she's understanding correctly that she should organize and order the evidence according to the order in which the legislation is written. I think that may mean she may be referring to the website, in the order in which it's listed on your website, as opposed to the strength or amount of the evidence.
Right. Within the regulations, it outlines what is required, and that we have recommended that they follow that in submitting their documentation.
If an individual is approved for a P2 visa and wants to bring family members to the U.S., is that possible?
Yeah, the spouse and children under 21 can accompany a P2 to the U.S. This is the P4 classification, and in that instance, the I-529 is used for the family members.
And this is Julia. I wanted to bring up one point. When we were going through the slide presentation, when we were discussing the period of stay for the Ps, there is a mistake there. The initial period of stay for the P1Bs, the P2s, and P3s is 1 year and not 3 years as we have on the slide. So I just wanted to make that correction.
And Tamara noted that we asked a question about, there was a question about waivers for labor consultation for O1Bs. Does this apply to P3s as well, that waiver of labor consultation?
And I believe Julia had indicated that she said it had only applied for the O1Bs and specifically just for those in the context of the arts.
And Bill Smith is asking if we have a question if a current consultation is required for P visas. Not quite sure what current that would be defined.
I would say yes, it's required. I certainly wouldn't think that we would be accepting evidence that is no longer relevant or is somewhat dated. So I'm not sure if that is what he was looking for, but
we have just a couple more minutes and see if there's a question we haven't touched on yet. Visa extensions, I don't think we've covered that. If a visa can be extended once the petition's approved.
yes. Well, the visas are issued by Department of State. So if the visa has expired and the person has an approved petition, they can apply for a new visa with the Department of State. Of course, people should be aware that a visa does not guarantee entry to the U.S. And also the visa expiration date shown on the visa does not reflect actually how long you are authorized to stay within the U.S. The entry and the length of authorized stay within the U.S. are then determined by CBP when they actually admit you at the port of entry each time you travel to the United States. So that's, again, talking about the different players in the process.
So there are 3 points I think it's helpful to emphasize. There's USCIS with the petition process and its own fees. The next point would be the consulate and the fee for the visa issuance there, and then actually border protection.
CBP, Customs and
Border Protection at the border when you come in.
And they had actually admit you into the country. So they kind of have the final say of whether or not you get in.
Great. It's good to reiterate that distinction of the 3 players in this process. And Bill has clarified that, or the question is, would a consultation used for a prior petition 1 year ago be acceptable?
So I'll lean on my colleagues. It looks like probably one last time as to whether or not there is a time frame for when we can accept a consultation, how old or how new it needs to be, I suppose.
If we're talking about the P classifications, they need to, we require a consultation from a labor organization for the event that you're coming, for the event that the petition is, petitioning for. So you cannot use an older consultation that was, because we want the labor organizations to be able to weigh in on this current, the beneficiary as well as the event that they're coming in for. So it would have to be a consultation with a labor organization for this beneficiary and for this event. And that's for the Ps. I mean, the only exception we make is the waiver of the O1B arts, and if that's within 2 years.
Thanks so much, Mary, for your comprehensive presentation, and to the offsite staff for your help in answering questions. That is about all we have time for this afternoon, and I want to remind everyone that the webinar will be archived on the NEA website. Look for podcasts, webcasts, and webinars, and we'll be taking questions for a live Twitter chat, and we will send out notification of that. It's Monday, July 15th. We'll keep you posted on the Twitter chat. So thank you all for joining us this afternoon.